report them.
Great.
So,
Okay. It is 6 o'clock, and I'd like to call the March 10th, 2022 Addison Township Zoning Board of Appeals meeting to order. If we'd all stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We could have a roll call, please.
Tony Spina,
Here.
Ed Brakefield.
Here.
Vice Chair Smith.
Yes.
Chair DeWitt,
Here.
Jay Sandler,
Here.
Bill Marshall, absent.
All right, if we could have a motion to approve the agenda.
I'll make that motion. There is one change.
Oh,
I see she's got it corrected. Never mind.
okay, so who made the motion?
Jay,
Jay? Who second?
I second.
Okay. All in favor, say aye.
Aye.
Opposed? Hearing none, motion passes. Next on the agenda would be approval of our last meeting minutes. That's be February 10th, 2022 minutes. We could have a motion to approve the minutes.
I'll make that motion.
And I'll second.
Okay. We have a voice vote on the approval of the minutes.
Roll call.
Roll call. Excuse me.
Tony Spina,
Yes.
Ed Brakefield.
Yes?
Jay Sandler,
Yes.
Vice Chair Smith.
Yes.
Chair DeWitt.
Yes. Okay. Okay, our first case tonight is case number 22-3. The applicant is Dr. Surendra and Jayshree Kawala. Hopefully I didn't say that. The applicant's address is 679 Gravel Ridge. Easement parcel address is 69 Gravel Ridge. And the parcel number is ID 05.22.153.021. And the zoning of the easement parcel is residential R-1. The applicant seeks an interpretation of the Township of Addison Code of Ordinances. Appendix A, Code of Ordinances, Dock Ordinance. Article 13, Lake Lot District Overlay, including section 13.02 and section 13.03. The applicant seeks appeals of administrative decisions from the ordinance enforcement officer and the district court disposition and property owner agreement. Okay, last month we had our public hearing, so the public hearing is now closed. And this is our deliberation meeting. And I'm going to ask that the applicant, if it has any more that it wants to present to the board on the interpretation request. And so the floor is yours.
Thank you very
By the way, I was under the impression that your co-counsel may want to participate by phone.
Yeah,
And if,
thank you very much
Okay,
for
so-
allowing that.
all right, thank you.
My name is Mike Lebo. It's nice to see you all again. I only want to make a couple of brief points about the difficulties the way this ordinance has been interpreted, has created. You all know basically what has happened when the township entered into an agreement with homeowner Mr. Dim, where our dock is located on an easement on his lot. When it was discovered that there were two docks on that lot that violate section 13 of the ordinances, the township, as you know, issued a ticket to Mr. Dim, who was the property owner. The Kawalas, they have a dock on their easement that they own on the same property, which has been there from around 1962. In 1993, it was moved over to the other side of the lot because the then owners of the property joined two lots together to make a buildable lot. And they asked as an accommodation with the Kawala's predecessor, would they agree to move the easement over, because otherwise it was running through their kitchen. So they did agree, and they entered into a second written easement in 1993, and the dock has been there, it's been on the lot since 1962, we believe. And what ensued eventually was, I know the township began vigorously enforcing the dock ordinance. We're not saying anyone's been singled out, but when the township went to this particular lot, they saw there were 2 docks on it. They spoke to the homeowner, Mr. Dim, and actually they had been on boats from the Koala's dock because of activities taking place on the island. And I should have said, the Koala's on the island in the middle of the lake. And they had an egress easement on its lot. Now, when the township came out and they looked at the property, they saw 2 docks, and they issued a ticket to Mr. Dim, the property owner, and apparently made no inquiries to Koala's. Then the township entered into an agreement with Mr. Dim where they agreed that we would drop the misdemeanor charge for having a second dock under the condition that you will remove the second dock completely, and if a third party should reinstall a dock there without your permission, the township will pursue the third party directly and charges were dropped. And then at the clause of the agreement, Mr. Dim went onto the easement and removed the Koala's dock, their personal property, and I believe took it out to the island and left it there. Now, I have basically one question that comes to mind about all this. If the township knew that the Koala's dock, what they call the second dock, was already in existence many, many years, decades, before Dim's dock was installed, and it was legally on an easement owned by the Koala's, would the township ever have entered into the agreement that Mr. Dim signed, which resulted in him removing the Koala's property? I ask it as a rhetorical question, but I think the answer is clear when you look at some other parts of the ordinance. First of all, violating the dock ordinance is not a civil infraction, it's a criminal infraction. And in Addison Township, Article 27 of the township's ordinance gives the zoning enforcement officer police powers, and he can delegate police powers to those under him, which means, acting as a police person, they can issue these misdemeanor tickets, which are, potentially $500, 90 days. What is funny about the way this operates is because normally in any criminal case, whether it's a misdemeanor or a felony, there has to be something we call probable cause. And there's 2 parts to it: probable cause to believe that a crime was committed, and probable cause to believe that a particular person committed the crime. So, law enforcement officers, people who can issue misdemeanor tickets, they do something called investigation. Now, if it's something the police officer sees when it's happening, he can, that's probable cause if he sees a crime being committed. But if the police officer or ZEO, the zoning enforcement officer, doesn't know the facts from observing them, like any other law enforcement person, you have to investigate. Now here, where the ordinance expressly gives equal rights to an easement owner and to a lot owner and a lessee, they all have equal rights under section 13, the first part of it, in 1302, says that they'll be treated the same. So when a law enforcement officer working for the township goes out to the lot and sees 2 docks, he is seeing, because there are 2 docks, he sees there's a crime. No doubt about it. That's probable cause right there. But the second part of the probable cause is who committed the crime. And this is where the ordinance maybe needs a little freshening up, because when you look at the situation, there's 2 docks there. Obviously there's a crime. But who's responsible? Now, we believe that Mr. and Mrs. Koala, Dr. Koala, who have been their property and their predecessors have for almost 60 years kept a lot of that property, kept a dock on that property legally through an easement, which was a public record, which when Mr. Gibbs bought the property would have been quite obvious. But between the two of them, the Kawalas and the Gibbs, who do you give the ticket to? Now, if you flip a coin, we all know that's arbitrary. And we all know that arbitrariness has no place in issuing criminal charges or even civil charges. So here, what happened was that the Gibbs got the ticket, and they were offered an opportunity, negotiated through attorneys, but then signed by Mr. Dim and Township, offered an opportunity, we'll dismiss the ticket against you, which was issued without probable cause, because there's no way of knowing, if you're just looking at it without any investigation, which dock is legal, or are they both illegal? So again, the ordinance doesn't deal with the two dock situation. It doesn't say, oh, if there was a dock there proceeding and a single dock out, then the second dock is illegal. I mean, that's logical, if you're gonna enforce two docks. It doesn't say that it's up to the discretion of the zoning enforcement officer to decide which dock to issue a ticket for, because that would be arbitrary. That would not pass muster in the ordinance. But the application, it has become very arbitrary. And even worse, the fact that the ordinance gives the zoning enforcement officer complete discretion. That, oh, I'll give it to the people who have the new dock, I'll give them the ticket. But I will dismiss the ticket, or I'll agree to have the ticket dismissed, as long as they agree to move the other dock, something the township couldn't do on its own. They couldn't go move the dock without finding a legal finding. There's due process. Township can't take somebody's property and move it unless there's due process. They go to court, get a judge involved. Here what happened, the township understood a court. They can't go move someone's personal property without some sort of judicial backup on it. But what they did, and this is because the ordinance doesn't really deal with the situation, what they did was, they told Mr. Dim, we're giving you the ticket. You go ahead and move the Kawalas property. Now, aside from the fact that the action favored one resident over another, which shouldn't be done without some legal reason to do it, there's the whole idea of putting citizens in a position where they're trespassing on someone else's property, they're moving something, and I'm not criticizing Mr. Dim. He did what he had to do. But this ability for the ordinance to be interpreted in such a way that tickets are issued without probable cause, and then the ordinance is used as a lever over a dock owner on the same property legally to get rid of his dock. It's completely arbitrary, and it's unfair. It's not equitable. You know, equity is a concept in the law that fairness, doing the right thing. If there's no other legal remedy, a court will fashion a remedy through equity to try and do justice. Well, I think in a sense, you have to look at the ordinance equitably. Look at what happened with equity in mind. Was it fair that the Kawalas dock was picked up and moved under these circumstances without any court hearing, by using a resident, by charging him with a crime to move it? That's not right. I mean, I know none of you think it's right. But it can be fixed. It can be fixed by the ordinance being interpreted in such a way that requires the zoning enforcement officer to investigate. And if there is more than one dock on the property, investigate, determine if one had priority. Because if you think about it, the dim dock went up, I think, in 2019. So many decades after the Kawalas dock was in place. If you think about it, it's just totally unfair to say, Mr. Dim, you can keep the dock as long as you move the Kawalas. It's not equitable. So unless you have any questions, I'm sure you understand my point. If you think of any, I'll be right here.
Okay, so now that the applicants made their statement, do we have any further questions we want to ask of the applicant or any?
Oh, okay. Your explanation was very good. But to boil it down, there were 3 docks on 2 properties. There were,
2 docks on one property.
the Dims do not have a dock on their island?
We're not talking about the islands not involved with this.
Yeah, well, it is their property.
Well, they can have a dock on their island, because it's their
I
property.
agree. There are 2 properties, the Dims property and Mr. Quala, Dr. Quala's property. That's 2 properties, and there's 3 docks. And that's the problem. I mean, boiled down.
I just don't see how you can say the island dock is part of this.
I'm saying their dock, their property, the island, has a dock, and it's fine.
I mean, you don't see that as a problem.
No, I don't. I'm just saying
Okay.
that,
How do you go there? You can't swim to that. You have to go by a boat.
well, if we leave the island out, then there's 2 docks on one property, and one of the docks had to go. I'm not aware that the township specified which dock had to go.
I think I read to you the agreement that the township entered into with Mr. Dim. We will dismiss the criminal charges if you cause the other dock to be moved.
Easement dog, we specifically
There you go.
wrote to the,
Copy the letter.
to the Mr. Davis.
Mr. Davis, if that's
There's
correct.
so-
So the
Easement document
agreement,
removed.
just listen, the agreement was drafted neutral. I drafted a neutral agreement. The attorney for Mr. Dim decided what dock would be removed.
His letter to us is absolutely opposite. He said all of this has been asked by this township.
Okay, so
Yeah,
he
yeah,
had a
very,
lawyer,
very
if
specific.
you want me to produce all the emails from the lawyer, where the lawyer changed the language, I'll do that for you.
I
But
don't
I'm telling you,
know.
let me finish.
But why would
Well,
it?
that's
Let
it.
me
We gotta have one at a time here.
I was working with the property owner's lawyer. The property owner's lawyer dictated what went into the agreement. I signed it. End of story.
You're
No,
saying that.
that's just
What-
one
one at
of
a
the
time,
others
please.
committed
Dr.
to-
Paul,
I'm not
please.
gonna answer their questions.
Okay, if you're not gonna answer the questions, I'd like to point out that you can read the agreement. I have a copy here.
Yeah, I got it right.
And to blame the homeowner's attorney for making a good deal for his client, that's who he has a duty to, is wrong. For the town, I was very careful to avoid saying anything about township council. The township council, yes, was involved in this and did sign the agreement. And to try and say we're not responsible for what's in the agreement is absurd. I mean, he has a public duty to do justice.
Honestly, it was not,
I'm just trying to get my head on straight on this thing.
I'm sorry.
I'm trying to get the thoughts straight here. Who's the property owner? You?
No,
Or
no.
Mr. Dim?
We're both property owners in
Are
sense
you?
that
Who
Mr. Dim
owns
is
the
the,
deed?
is the fee owner
Mr. Dim.
and the
Who owns
Koalas.
the actual deed to that parcel that
The-
ends with
the
2-2?
Dims.
Then that's who we should be talking to, the
No,
Dims.
not really, because your own ordinance says, and I can read it to you.
Okay.
Your ordinance says that it doesn't matter if the interest comes about by fee ownership, lease, or easement, exactly as here. So in your ordinance says, look, if somebody's got a right to access the water, it doesn't matter if the right comes through a deed, doesn't matter if it comes through a lease, it doesn't matter, as long as they have that legal right, and they do.
So what you're asking, let me see if I got this right, the property owner, I think you're the property owner? No, whoever the property owner is?
Property owner's not here. Doesn't- I
Okay,
don't think
Mr.
so.
Dim, you're asking him, property owner, to get rid of his dock so you can have one, is that right?
No, that's not right. We're not asking him to do anything. We're talking about the exercise of governmental power. And that is a problem. We have an easement. We can easily go to court and straighten out any differences that are private between the Koalas and the Dims. They have a contract between them that runs with the land. It was there when the Dims bought the property. What we're talking about, I mean, should concern you, is that you have the ordinance being manipulated. I don't know why the township wants to get rid of the Koalas dock. even though it's been there for decades. But there's some reason, and it's not appropriate, because it was already in existence. What's wrong here is when the township basically uses its ability to bring criminal charges and dismiss criminal charges, they're using that to cause my client's property to be taken. And not just the property, but the property rights. To meaningfully use that easement to get to their island.
94, 88.
Move doesn't count. Go to trial.
Okay.
Okay, can I start over again? There was one property with 2 docks. Okay, and that violated the ordinance.
Exactly. Now, the question is though, and maybe you can answer this one, is until the Dims dock went in 2019, there was one dock legally located on an easement.
Yeah.
So does that mean that any other property owner who has a dock on their property by virtue of selling an easement off or something can say, I don't want that dock anymore, I'm gonna put in my own dock, and then I can do what Mr. Dim did, get a ticket and agree that if they dismiss the ticket, I'll get rid of the other dock.
Okay, I'd like to just clarify your language just a little. There was one dock, and it was not on the easement, it was
No.
on the property.
No, the Kowal's dock was on the easement.
It happened to be placed on the easement, but it
No,
was on the
intentionally
property.
not happened. They didn't have a right to put it anywhere else, but they had a right to put it on the easement.
As I understand it, that easement was written from people to give people
Well-
access to the water. There was no right for a dock.
I know we talked
In the
about
papers
that,
I've seen.
but you're not correct in that there's prescriptive easements, there's all kinds of easements. for
Well,
the
we have
dock.
a
But that's
pretty good
between-
mind here. Do you have anything to add? I mean, the easement that I read was from these people to those people to allow those people to
Easement-
access the water.
An easement in
edge.
Michigan is a contract,
Yeah.
it's between 2 parties.
Right.
You're not part of that contract. So that the easement relationship is between the Dims and
Yes.
these people.
But the easement only
The
allowed
easement granted access to the water's edge.
access to the water's edge.
It didn't specifically say anything about a dock.
Right. And that is to be inferred or not? No, I would think no.
I think if there's a dispute on what the easement says, that's beyond your jurisdiction.
Agree. I mean, if you start inferring things, I'd infer quite a lot of stuff. Okay. Okay, there was 2, okay.
No, the language of the easement says it's for ingress and egress to go to the island. And the only way we can go to the island with the egress is through a boat.
Okay.
This requires a dock, so it is implied that it will be dock. And anyway, the dock has been for more than 15 years, so we get a
Okay.
prescriptive
Okay, when I read the,
easement, prescriptive dock.
okay, when I read the easement, it did say nothing about accessing the island.
Oh, no,
It
says
said
ingress
access
for
the
sole
water, the edge
purpose
of the
going
water.
to the island.
Access the water is what I read.
No, not access to the water, to the island.
It does say.
It specifically says, for, the whole purpose of the easement is for us to reach the island.
And it's very shallow there, so, you know, if the easements didn't have any meaning, they need to have a dock. But the dock is pretty much a for sure thing legally because it's been there more than 15 years continuously. But that would be between the Dims and the Kabalas. What we're talking about here is how the ordinance should be enforced and interpreted.
Also, there's one more point, my nephew became friendly with Dim's daughter, and she said, you know, we can't have a dog, because there's already a dog. So, but for some reason we can't, because he asked, why do you only use canoe? Why don't you all have boats? She said that because you're not allowed to have a dog. Then, 2019, this ordinance started getting enforced, so suddenly his dog came on. So he was all along aware that our dog and our easement has priority over another dog being put. We didn't want to bring it up because it was conversation between 2 kids. But there was for a long time understood.
What I think is important is that you have to look through this, through the prism of there was a legal dock there. You can't look at it as if there's a priority in ownership interest or a priority in right to have a dock there? Because there is no priority between the owner of the property and the easement owner. That's what your ordinance says, exactly that. So if you want to say, well, maybe the homeowner should have superior rights, then you're ignoring your ordinance.
Also, the ordinance came after the dock was there for almost 30 years. So the ordinance does not apply to that. So they should accommodate, they should grandfather and accommodate. And then make an exception that they can have two docks, one for the owner of the property and one who is owner of the easement. If we have equal right than them, as far as the docks are concerned, dock on the easement has equal right as dock from the ownership. So if they have equal rights, and ours has been there for
And we didn't have problem for 3 years, 19 until 2019 until now. So let him have and we can have.
Also, he didn't have problem when he first came, before the ticket came, he cleaned up the trees and made excess, and I went to pay him money so that he had cleaned up the trees on the easement. He said, no, I don't want that, your money. He was all in our favor of easement remaining, dock remaining is dock remaining. Till the city intervened, and then when he felt that maybe his dock will go, then he became hostile towards us, but he had no problem.
So I'm just gonna tell you one more thing. This case was brought against the Dims, right? And they resolved it with their attorney.
Right.
What I did on the agreement, which nobody seems to pay attention to, council.
Oh, wait, one at a time.
Yeah, Jeff, I'll.
They made the property owner made a decision on what dock the property owner thought should be removed. I incorporated that into the agreement. But because I knew that there might be additional rights, I put a tagline into this agreement, which is in no other agreement, that nobody seems to pay attention to. And it says, if the dock is reinstalled, then the township will deal with that entity. Who would that entity be? It would be these people. Mr. Dim never raised the defense of grandfathering. Mr. Dim never raised the defense of what dock was there first. Mr. Dim simply said, I'm going to remove a dock. I was the one who said, well, then if the dock goes back in on the easement, I'll deal with those defenses at that time.
Excuse me, just a second, please. My co-counsel, Mr. Lee, wanted to say something, if you would allow that, please. Jeff?
Excuse me. Excuse me.
1 second, please.
Can we make sure that everybody can hear? We have to be
Can he
quiet. so
bring
we
the
can
phone
hear.
up here?
And you might want to put it by the recorder so it's part of the record.
Thank you. Okay. Go ahead, Jeff.
Thank you. I'm Jeffrey Lee. I'm an attorney in Farmington Hills and calling in from Florida, so I appreciate the accommodation to appear before you tonight. The Dims received a ticket for having two docks on the property on June 2nd, 2021. Somehow there was a notice that was sent by the 52nd, 3rd District Court in Rochester Hills that there was going to be an arraignment and a pretrial on October 14th, 2021, several months later. The Kalwalas were notified by the court that there was going to be this pretrial, and they came to me and I said, you know what, go there and participate in the pretrial if it's permitted, because you ought to be able to work something out with the township attorney. They had a cordial relationship with the Dims at that point in time. In any event, that was scheduled for October 14th. On October 6th, a day or so after the Kalwalas told me about this ticket and a pretrial hearing, I wrote the following letter to Mr. Dim in an email. I said, hi, Jeff. His name is Jeff also. I said, hi, Jeff. This is Attorney Jeff Lee, and I'm writing to you on behalf of the Kalwalas. Here is my suggestion to resolving the two dock misdemeanor tickets you received from Addison Township. contact the township attorney, Robert Davis, and ask him to either adjourn the pretrial, arraignment pretrial, or on 10/14, or dismiss the case without prejudice to give you time to seek a variance to allow a second dock at your property from the Addison Township Zoning Board of Appeals. You have a perfect case for a variance. Parentheses, I've done dozens of them, and also sat on my community CBA, close parentheses. Your situation is very unique. Your lakefront serves two residences, yours and the island. The Calwalla's dock has been in place and has been used upwards of 60 years to provide them access to their island home. You should be entitled to a dock too. This satisfies the ZBA standards that call for either a practical difficulty or a hardship. You have both. Your situation was not self-created, and the ZBA should grant a variance allowing you a second dock. This will not establish a precedent, as the situation is unique only to your property. It should be a no-brainer. But you'll need to initiate the procedure. I'm sure your lawyer, whom I met at his office a couple of years ago, will be able to help you. I hope this note helps you resolve this matter. Feel free to respond if you'd like. Regards and good luck, Jeff Lee. So that was my reaching out to Mr. Dim. That was October the 6th. On October the 8th, 2 days later, before the 14th court hearing, Mr. Davis and Mr. Dim created this letter on Mr. Davis's stationery, agreeing to dismiss the case if Jim would move the dock, and you know the rest from what Mike Lebo just indicated to you. So I think, again, at that point in time, the Calwallas and the Dims had a cordial relationship. They each had a dock, and it wasn't until the township intervened that disturbed that relationship. But it's the Dims that should be petitioning the ZBA to grant them a variance to have a second dock. Our dock, as Mike Lebo just indicated, was first. It's permitted under the ordinance because we have an easement right to it. And so I just wanted you to know that we reached out to the Dims before they ever made this agreement with the township. And I suggested to him that it should be he should have a no-brainer issue going to the ZBA asking for a variance. He's got a unique situation here, and it should be granted, but it should be at his initiative, not the Calwallas. Thank you.
So let me respond to that. There never was a ZBA application. I was aware that they were talking about that. And number two, I want to make it clear to this board, I never met, I never conferenced, I never emailed, I never spoke on the phone, ever with Mr. Dim. The first time I met Mr. Dim was at the last hearing. I only dealt with his lawyer.
Going to retrieve the phone if that's okay. Thanks.
Can I see just one thing? When he first received the citation on June 2nd, Mr. Dim went to the ordnance department and talked with the ordnance officer and said this is a unique situation in which the ordinance does not apply because there are two people who own this dog. It's not two dogs by one person. And so it should not apply to our case, and both of us should be allowed to keep our dogs. And the ordnance officer said no, and his email says, he said specifically to him, not you choose which dog to remove, as Mr. Davis keeps on saying, that it was his option. The ordnance officer said, remove the dog belonging to Calwalla's. I have a text from him, email from him saying that the ordnance officer asked. So now I have no choice. And if I had known that I would be ordered to remove your dog, I would not have cleared the trees for you. So because he wants to rehab his whole house. And so this year, he was cleaning up, trying to get more area. So he cleaned the trees from the ordnance. And the ordnance office, from the easement. The ordnance officer specifically told him to remove Calvado's dog. So this thing that the township was never in favor of one over the other and entirely came from Dib's attorney is not true. Right from the beginning, the township was biased against us and favoring Dib's, which is not fair.
What do you mean
because
by
we are equal.
biased?
Oh yeah, there is bias.
What do you mean by that, sir?
He's not gonna answer your question.
I will not answer if it becomes necessary, I will answer, but there is a bias because you were very quick to take, okay, let me explain why the bias.
I never met you before.
Okay, Mr. Davis, I'll tell you why it is biased. Let me,
Sure, go
because
ahead.
when Dim's lawyer contacted you, you were all ready to respond to him. When we called, my wife called, we left voice mails, she sent a letter to you and a lawyer called, but you had no concern about returning a call. So you are also, we are citizens too, and of the, we have property in this township, you should respond to us too, you should represent us too, not just Dim's interest and what the Dim's lawyers say. So my point is, yes, there was
Okay.
prejudice right from the beginning and against us.
Okay.
So why didn't you respond to our letters and calls?
Let me explain
And
something. Let me-
are you not lawyer for the whole
Yeah,
city
let me-
and all
yes,
the residents of the
Let me
city?
explain to you the answer to that.
Uh,
Number one, I received these complaints from the township. The building official makes a decision on who's gonna get a citation. I don't even see the citations until they're part of the court system. When they get into the court system schedules a case. The case was against the Dims. So my communication was with the Dims.
Mr. Listerman was waiting in court for us. When we walked in, he was waiting for us. So
Yeah, I was in the
all
parking-
along
I
you
know, I
were
was in the
aware
parking lot.
that you were violating a right and preventing us getting a due process in the court.
You
So Listerman was waiting for us and he
Right.
told us.
I'm just telling you,
There has been
the
dismissed.
citation was issued to the Dims.
I just have a quick question. Why wasn't the application for a variance filed?
It's for the Dims to do. We can't ask for a variance on their property. They have to ask for variance. If we could, we would.
But, and why aren't the Dims here?
And I don't understand why this keeps going back to why aren't the Dims here? This is a basic issue of the Koala's rights, their property rights, what they paid for.
So I'm gonna say-
And I say, I'll just quote Shakespeare. One time, I don't know much about Shakespeare, but I know when he once said, "Thou doth, methinks thou doth protesteth too much." And I would say it applies to Mr. Davis.
That is brilliant. Let me just read the sentence again that's in the agreement. If any party should reinstall the second dock, meaning the easement dock, the township will deal with that party at that time. Meaning the defenses, the arguments that the easement holder might have would be dealt with at that time. And what I was trying to do here was I was insulating Mr. Dim from being part of that dispute. So if the easement holder reinstalls the dock, we would deal with the easement holder's defenses at that time. Mr. Dim was not in a position to raise the defenses for the easement holder. I think you should move forward with your,
Yep.
Wait,
one at a time, please, one at a time.
I have a copy of the letter. If you'd like to actually see it.
they have it, it's right in front of them.
Oh, okay. Well, I think it bears reading, that's all.
If there are any further questions, I'd like to ask a board member to make a motion.
I'd like to make a motion. I've read everything. I've got so much here. If you don't mind, I'd like to make a motion.
Sure, please.
I'd appreciate not being interrupted. This is a very long motion. I'd like to make the motion. The motion will have several parts to it because this motion addresses all of the relief sought by the applicant. The motion is based on the record. The record includes the public hearing from last month, which was followed by presentation made by the applicant and the legal counsel. The motion is supported by citation and issued to the deposition of the citation at the district court, where the cited property owner was represented by legal counsel at all times. This motion is further supported by my review of the jurisdiction of this ZBA, as well as the controlling ordinances on asking the ZBA for relief. Finally, the motion is based on a review of the rules used in Michigan to interpret a zoning ordinance, as well as a plain language reading of the ordinance issue. First, I move that we uphold the decision of the building official, Mr. David Garrick, to issue the citation giving rise to the district court case number 21-002806-OM. That citation was limited to the issue of a lake lot having 2 docks. That was the determination of the building official, and I see nothing in this record to the contrary. Additionally, the challenge to this decision was not timely made under the 60-day shall standard found in section 2807. Second, I move that this ZBA has no authority to review, question, or modify the resolution of the citation in case number 21-002806-OM at the local district court. I see nothing in this record that makes it possible for this ZBA to expand its jurisdiction review to the decision by the township attorney to resolve this matter. I also see no authority of this ZBA to review a district court order. Third, I move that the ZBA has no authority to interpret or act on an easement between 2 private parties. An easement is a contract, and the township is not a party to this contract. Fourth, I move that the zoning ordinance be interpreted as follows. Addison Township zoning ordinance, Article 13, Section 1302 states that the provisions of this article shall apply to all lake lots and all lots having access to a lake, regardless of whether such access is by easement, common fee ownership, single fee ownership, lease, condominium, or other means. The plain language distinguishes between lake lots and lots. 1302 does not state that lake lots shall be defined to include lots having access to a lake, regardless of whether it is by easement. Section 1302 places the public on notice that if you have access to a lake via an easement, you are bound by the provisions of Article 13 as written. The Addison Township zoning ordinance at Section 1303 states a lake lot's zoned for single-family residential use may include as an accessory use a single private dock which shall not exceed 35 feet in length or 6 feet in width, provided that not more than 2 boats shall be moored at such dock, and boats which are not owned by residents of the lake lot shall not be permitted to be moored at such dock. Section 1303 authorizes a single dock and defines its dimensions with clear and particular language. There is no language in Section 1302 or 1303 which states that if there are 2 docks present on a lake lot, the property owner must remove the newer of the 2 docks. That's my motion.
Support for the motion?
I'll support.
Okay. Does everybody understand the motion? Okay. If we could have a roll call vote on the motion?
Tony Spina,
Yes.
Ed Brakefield,
Yes?
Jay Sandler,
Yes.
Vice Chair Smith,
Yes.
Chair DeWitt.
Yes. Motion passes. Okay. That being said, our next on our agenda is our public forum for the night, where members of the audience can make comments to the zoning board. We won't be responding to those comments, but they can make them.
Okay. Scott, this room from 430 Campbell. We heard some interesting things here
Speak a little
tonight.
louder, please.
Sure. Can you hear me now?
Louder, louder. Scott, come on up.
Can you hear me now?
Yes, sir.
Okay. So we heard some interesting things here tonight. But we've heard interesting things about this topic for a couple of years now. I heard something mentioned about the power given to folks to write a criminal misdemeanor citation. We give power to pilots to fly planes, and we give power to doctors to be doctors and work on people, and we give power to folks to write a citation. If I jump in a plane and I didn't follow the protocol, and if my doctor grabs that scalpel and doesn't do an investigation, people will die. But I understand across this whole country and right here at home, we've heard about, I've given previous examples, I know of at least 5, probably more out of this 55. I could easily get a dozen people that would give hard examples of how the idea of a citation needing to be written was sparked, and what appears to be 0 investigation took place, and then we wrote a bunch of citations. I understand that. Sometimes I do my job without doing enough investigation either. I'm not a commercial pilot or a doctor. If I were and I acted that way, people would die. I'm not saying I got a fix for it. I feel like that's part of what we've heard tonight. So I understand the decisions of tonight and the past several decisions. I understand the position you're in as ZBA. No one was really asking you to change anything or make legal decisions. And of course, this process has taught us a lot. We've met a lot of people in the township and around the lake that would have never met each other. So I empathize with the situation, but I did want to make it clear that we have a hard pattern of issuing citations with a lack of investigation, and it's cost every one of you taxpayers money, including myself, and a lot of people time, and the Davis Law Firm time to be down at the district court. And these things, I think as we've gathered tonight, some of us understand, could have been avoided with that little piece called investigation before you issue that citation. Have a good night.
Thank you, Mr. Deverell.
I came to the meeting, I'm out to talk. Mike Bartlett, 1469 Rochester. I think the Koalas, and I'm terrible with your last name, sorry, sort of got wrapped up with the Dims in this whole thing. And while the Dims have resolved their issue, these 4 folks were apparently tangled up like a weed eater in a weed with somebody else's resolution. And it sounds like what they need to do is put their dock back in, get a citation if the township wants to issue them a citation, and then have their day in court to fight their citation. Because that's the only way they're gonna get resolution, because what we bounced around here was the Dims' issue without really having through court resolution to a citation that was issued to them. So while the Dims resolved their issue, they entangled these poor folks by moving their dock. So I would suggest that they put their dock back in. I'll just put it out there. And I would suggest this township have enough foresight to not issue a citation to them as it being grandfathered, because it's been there for years to allow them access to their island. And we all move on with our lives. Otherwise, have a day in court.
Thank you, Mr. Brown.
Okay, anybody else is willing to speak or make comments? We'll move on to our other business. First would be correspondence received. Any correspondence received by the board? No correspondence received. Next item would be zoning board reports.
Zoning board is up to date, there's nothing pending and nothing real exciting, I guess, going on right now.
Okay. I would assume that stays true for the planning commission, Mr. Smith.
Sir,
That would be stay true for the planning commission as well?
that is the planning commission.
Yes. Okay. Next would be a motion for adjournment.
I make a motion for adjournment.
I'll second.
Support, vote. All in favor?
Aye.
Opposed? None. Motion passes. Meeting's concluded.